everyone, you're watching News Epicenter with me, Marya Shakil. It is a big boost to the Hindu side in the Gyanvapi legal tussle. The Varanasi District Court has upheld the maintainability of the Hindu side's plea, where 5 women filed a petition seeking permission for daily worship of Hindu deities, claimed to be located on the outer wall of the Gyanvapi mosque. The Muslim side opposing the plea argued that the mosque is a Waqf property and questioned the maintainability of the plea, an argument that was rejected by the district court. The order stated that the suit is not barred by any provision of the Places of Worship Act, adding that the Hindu side was able to lay the foundation for the Hindu character of the site, which existed on and before the 15th of August 1947. Remember, the Places of Worship Act states that the evident religious character of sites on the day India got independence cannot be changed. The order also stated that the Ayodhya verdict establishes the right to initiate suits to protect deities as well as a legal personality for deities, adding that destruction does not result in the termination of a pious purpose. The order also says that devotees were freely allowed to worship Ma Shringar Gauri till 1993, but access was restricted by the UP government without a written order. Remember, that order came right after the demolition of the Babri Mosque in 1993. The court ruled that the plaintiffs are only demanding the right to worship and there is no place or plea. In fact, there is no plea to declare the disputed property as a temple, so there is no ownership claim here. The Muslim side has said they will approach the High Court to oppose the order. They will be challenging the order. The next hearing in this case in the lower court is on September 22nd. While one obstacle has been crossed for the right to worship, it opens a legal debate on a host of different issues. This sparks the debate over the ambit of the Places of Worship Act 1991, as it gives validity to the videography survey of the Gyanvapi complex, where the Hindu side claims there is evidence of a shivling in the Wazukhana. This also gives a push to the larger argument over the mosque itself, where it is claimed that a temple was demolished to construct the Gyanvapi complex. This also comes ahead of a crucial hearing in the Supreme Court of a plea calling for the abolition of the Places of Worship Act 1991, saying it is arbitrary. The court order also boosts the argument of the Hindu side in other disputes as well, namely the Krishna Janmabhoomi dispute in Mathura. So how should we look at this ruling? Is this a boost to the fundamental right to pray, or is there a bad legal precedent? Because there's subservient, there is a method in which the 1991 Places of Worship Act has been subserved. And does this really open dangerous Pandora's box? Before I get the guess, here's what happened today.
Celebrations outside the Varanasi court after the verdict on the Gyanvapi dispute. In a big win for the Hindu side, the court agreed to hear a petition filed by 5 Hindu women seeking the right to pray inside the Gyanvapi mosque. The court rejected the Muslim side's argument of Order 7, Rule 11 and held that the suit filed by Hindu parties is maintainable in court. There is also no bar on redetermining the religious character of the complex.
The only issue was whether the suit is barred by place of worship or not. That was the only question.
Earlier, a lower court had ordered filming of the mosque complex, and a leaked report to the court stated that a shivling was found inside the mosque's Wazukhana.
Therefore, the artificial walls which are existing beneath the Wazu area has to be demolished first, because let me tell you that the arga of the shivling is still to be found.
The Muslim side had claimed that the Gyanvapi mosque is a Waqf property and had questioned the maintainability of the plea.
ये जो आज ऑर्डर आया है, इससे देश में अब बहुत सी चीजें शुरू हो जाएंगी। 91 का एक्ट इसलिए बनाया गया था ताकि इस तरह के कॉन्फ्लिक्ट जो है वो हमेशा के लिए खत्म हो जाए खुदा ना खास्ता अगर हम 80 और 90 के दहे में वापस चले जाएंगे तो ये हर जगह पर एक डिस्टेबलाइजिंग इफेक्ट पैदा हो जाएगा.
When the hearing commences, the court will decide if the 5 Hindu women can access the Shringar Gauri complex. But will it open a Pandora's box for other disputed religious structures?
And joining me right on the top of the show is Vishnu Shankar Jain. He is the advocate of the 5 women petitioners. Vishnu Jain, really appreciate your time. It's a big step forward, certainly, for the 5 women petitioners of yours. The district court clearly said that it's not about ownership, but it's about right to pray. But will your petitioners stop at just seeking the right to pray, or will the petition eventually change and look at challenging the overall religious character of the Gyanvapi mosque?
See, very good evening, Marya, and I'm so happy to be there on your show. The point in issue is, and let me tell you that there are 6 suits which are pending before the Varanasi Civil Court, and this is just one of the suits. The other 5 suits are filed with the relief of title. So we are claiming title over the property in question, and this suit is for right to worship. The point in issue is that in this particular suit, the commission was ordered, and now the report of the commission is there. And as per Order 4 Order 4A of the CPC, all these suits have to be clubbed together and tried together. And when that will happen, the report of the commission will be read in all the suits. So it is not just right of worship. There is a title relief also which is pending in other 5 suits which have been admitted. Notices have been issued, and the Masjid committee has still not filed their reply. So that's the whole long and short of the matter. And so far as this particular issue is concerned, let me tell you that in this case the Places of Worship Act was not attracted. We had argued it for a long time before the civil judge as well as before the district judge, Honorable Mr. Justice A.K. Visheshwar. And the fact of the matter is that in this case the Waqf Act is also not attracted. So all these are the points and the legal arguments which we made before the court, and therefore the application under Order 7 Rule 11 has been rejected. And now in future the commission report objections are already invited from the Masjid committee on the commission report, and if they don't file that, the commission report will become final and it will be read into evidence, and in future other evidences also will be led in this matter.
Okay, given the nature of evidence collected so far, Vishnu Jain, will you seek scientific survey of the evidences?
See, definitely as per Section 45 of the Indian Evidence Act, a scientific survey is required to establish our claim, and I had already moved a petition before the Honorable Supreme Court seeking carbon dating of the Shivlingam which has been found. The Honorable Supreme Court was pleased to direct me to file my application before the trial court. Now those applications will be filed. Apart from that, apart from scientific survey, the artificial walls of the Shivlingam which has been found beneath the Vazu area has to be demolished to see the Arga of the Shivlingam, and therefore other further ASI surveys and other scientific demands will be made in the future.
Okay, since you're saying that this is just a beginning here, you will be challenging the entire nature of this structure as well. You're talking about the title suit as well. Help us understand, Vishnu Jain, because you are clearly saying that the Places of Worship Act 1991 doesn't apply here, neither does the Waqf Property Act apply. Talking specifically about Places of Worship Act 1991, should that be repealed because there is already a petition pending in the Supreme Court?
See, Places of Worship Act, we have challenged the constitutional validity, and it's a dream situation when Places of Worship Act will be repealed. That's a separate issue which will be debated and argued before the Supreme Court on 11th of October before a 3-judge bench. Now the point in issue is this, that within the framework of Places of Worship Act we have argued and we have made the Honorable Court to reject the application under Order 7 Rule 11, and the argument is precisely this, that under Section 4 Subclause 1 of the Places of Worship Act, the religious character of the property in question has to be determined, which was existing on 15th August 1947, and therefore on 15th August 1947 we have categorical pleading in our plaint that this property in question was having all the characteristics of a Hindu temple, and before 15th August 1947 also it was having all the characteristics of Hindu temple. And let me tell you that till November 1993, Vyas ji used to do puja in the so-called Tehkana beneath the mosque, and on the western side of the mosque till November 1993, all the women devotees and all the devotees used to worship Ma Shringar Gauri every day till November 1993. It is only in November 1993 Vyas ji has been ousted from his position from the Tehkana, and the puja of Ma Shringar Gauri has been restricted only to one day in a year. So the point in issue is that which kind of masjid can exist in this country where on the western wall the puja is happening from time immemorial on the western side of the mosque, and beneath the mosque Vyas ji is doing puja, and in the center of the mosque where Wazu is there, Shivlingam has been found. And I am not saying, Marya, that whatever I am saying is the final authority and the final verdict. Lot of work has to be done in the future. The scientific evidence has to be led. If one side is claiming it's a fountain, if the other side is saying it's a Shivlingam, it has to be gone into by an independent agency, by an expert agency, and all those evidences has to be led and brought on the record before the Honorable Court, and then only the final verdict will be there. But today, let me tell you what the Muslim side and the Masjid Committee is trying to say. They are saying that if we have said it's a fountain, please reject their petition under Order 7, Rule 11. We need not go further into this question. Against that approach, I have an objection, because if there is a dispute, this dispute in a democratic setup has to be resolved by courts of law. This dispute cannot be decided by the parliament. This dispute cannot be decided on the streets. In a democracy and in a democratic setup and a civilized society, all these disputes can be decided peacefully in a court of law. And the Muslim side was given ample hearing. Masjid Committee was given ample hearing to make their point before the Honorable Court, and after hearing them, this order has been passed.
Okay, my final question to you. Since you're talking about the Masjid Committee, the Anjuman Intizamiya Masjid Committee have already moved the Allahabad High Court. What next for you?
See, we will definitely file our caveat before the Allahabad High Court. We will request the Allahabad High Court not to grant any stay in this matter, because this is an issue where the trial has to go on. We will ask for day-to-day trial of the matter. We will ask fast-track courts to be constituted, and this matter should be referred to a fast-track court, and day-to-day trial should happen. And ultimately, the point is that all these disputed questions of fact, Places of Worship Act attracted or not, whether this property is waqf or not, it has to be gone into and looked into by cogent evidence, and that's what precisely the Honorable Court has ruled today.
All right, Vishnu Jain, really appreciate your time. Thank you so much. Let me bring in other guests on this debate. Parul Khera is a Gyanvapi petitioner. We also have Talha Rashidi. He is a lawyer. Talha, I'm going to come to you first. You heard from Vishnu Jain. He has talked about the entire timeline, that it doesn't stop at just the right to pray. It is about title suit. They are claiming that this Gyanvapi mosque was essentially a temple. There should be scientific survey, and that's where this entire case is heading.
A very good evening, Marya, to you and your viewers. That's exactly is the question here. That exactly is the question. You know, this order will open a Pandora's box. You know, this order will have severe repercussions, and it will start a new trend, as it has been already said on your show by the lawyer of the ladies who have filed the petition. You know, this order will open a Pandora's box, and there will be all sort of petitions and new suits and new petitions being filed throughout the country in different matters, and this will create a havoc-like situation. And that's exactly why the places of worship came into existence in 1991, to prevent such things. This case should have been nipped in the bud itself by the honorable
do you think the entire
the manner
in which the Anjuman Intizamiya handled this case in the district court in itself was problematic? To bring in the entire Waqf Property Act and say that this is Waqf property, that is the reason why it should not be done. The fact is that they were asking for right to pray, and there is already once a year these 5 women petitioners go there and exercise their right to pray. Could efforts have been made for out of court settlement in this case?
You know, that has to be decided by the custodians, you know, the Masjid Committee, the Anjuman Masjid Committee, that has to be decided by them. Consensus could have been created if the both parties would have agreed upon. But Marya, if you go on the ground, if you visit the place, the Gyanvapi corridor and the campus, the situation was so there was no calm as such, and the situation, these people belonging to the masjid committee, they are very common people, and they were under undue pressure from the administration, from the media, from the every corner of the place. So there could have been some mistakes on their part, if we can say, in proceedings, but that's a different thing altogether.
Okay,
there are cases where in some
Parul, it looks like that this is going to be a full blown legal battle. कोई बीच का रास्ता नहीं है.
देखिए, बीच का रास्ता तब निकलता जब ये हमें बोलते कि आप पूजा करते थे, आप पूजा करते रहे. इन्होंने ऐसा कभी नहीं कहा, चाहे ये हो, अभी ही रिप्रेजेंटिंग मुस्लिम साइड, ऐसा कभी हुआ नहीं. और अगर आप जाए अंदर, अगर आप जाए मस्जिद में, तो देखेंगे वहां तहखानों में हमारी we have our deities, we have our Jyotirling, there is Ma Gauri, Shingar Gauri Puja that used to happen, and it is very evident that it's not a masjid. ऐसा कौन सा डोम है जिसके नीचे एक और मंदिर का डोम है? I mean, कौन सी ऐसा मस्जिद है जिसकी दीवार जो है वो मंदिर से जिसकी दीवार मंदिर है? तो ये मतलब इसे बता देना. और अगर जहां तक प्लेसेस ऑफ वर्शिप एक्ट की भी बात है, तो वो यही है कि 15 अगस्त 1947 में जो रिलीजियस कैरेक्टर था वो बरकरार रहे. शिवलिंग तब भी था और आज भी है, और पता नहीं कितने सालों से है. वो तो जैसे अभी विष्णु शंकर जैन जी भी बोल रहे थे कि आर्कियोलॉजिकल सर्वे होगा, कार्बन डेटिंग होगी, उसके माध्यम से हम बता देंगे. क्योंकि ये जो है, ये हमारे शिवलिंग को कभी फुवारा बता देते हैं, कभी बता देते हैं कुछ, टेक सम ऑब्जर्व्ड.
Is the Muslim side fighting a losing battle? That's where it's all heading, clearly.
No, it's
it's very evident. It's very evident, Marya.
That no, it's not. It's not. Namaz is being offered there since last 600 years. इन्होंने
and our Shivlingam is there from I don't know how many years. From before Muhammad Ghori,
let me respond to you.
Demolished it in 1194. So our religion sentiments are also there, and it is there from way before your existence.
देखिए, पहली बात, नमाज ऐसी जगह पे हो ही नहीं सकती, नमाज जायज ही नहीं होगी जहाँ पे कोई मंदिर हो या किसी अन्य धर्म के मानने का कोई भी धार्मिक स्थल हो, तो नमाज तो जायज ही नहीं होगी. अगर ये मुगल राज में, अगर मुगल राज में बनी थी, औरंगजेब ने बनाया था या किसी और ने बनाया था, तो जो पूरे देश का बादशाह था, वो कैसे जबरदस्ती ऐसी जगह पे मंदिर बना देगा और पाप का भागी बनेगा कि जहां पर मंदिर हो वहां पे मस्जिद बना दे? जो पूरे देश का बादशाह था, जहां वो जिस जमीन पे हाथ रखता वो जमीन उसकी होती. आप बताइए, धार्मिक हमारे धर्म में ऐसी जगह पर मस्जिद नमाजी नहीं हो सकती जहां पर मंदिर हो या किसी भी धर्म की कोई पूजनीय स्थल हो. तो ये चीज कहना कि अगर ये चीज कहना कि वहां पर शिवलिंग था, ये अपने आप में इट्स सब जुडिस, सो आई कैन नॉट कमेंट ऑन दैट, बट वी डू नॉट एग्री ऑन दैट. देयर वाज अ वजूखाना, देयर इज अ वजूखाना, देयर विल बी अ वजूखाना, and you have to accept that. और ये मैं आपको बहुत स्पष्ट तौर पे कह रहा हूँ कि ऐसी,
आप हमारे शिवलिंगम के ऊपर वजू करते थे.
बिकॉज वहाँ
बताइए ना व्यूअर्स को, वजू पे क्या करते हैं?
मैं आपको साफ तौर
शिवलिंगम के नीचे आप समझिए, इट हर्ट.
मैं आपको ये कर ही नहीं सकते. हमारे धर्म में किसी के धर्म का अपमान करना जायज ही नहीं है, और किसी के धर्म के स्थल पर आप मस्जिद बना ही नहीं सकते. नमाज जायज नहीं होगी. मैं खुद नमाज पढ़ा हूँ, मैंने ज्ञानवापी में नमाज पढ़ा है, मेरी नमाज जायज नहीं होगी. मैंने अपनी आंख से देखा है, अंदर का वजूखाना भी देखा, उसी वजूखाने में वजू किया है. मैंने ज्ञानवापी में नमाज पढ़ा है. ज्ञानवापी के चारों तरफ आपके मंदिर है, पूजा करती हैं आप. एक छोटी सी मस्जिद है, आप उससे भी बर्दाश्त करने को नहीं तैयार है. आप बात कर रहे हैं आर्बिट्रेशन की, आप बात कर रहे हैं आउट ऑफ द कोर्ट सुलह समझौता की. आप पूरा वाराणसी, पूरा ज्ञानवापी कॉरिडोर इतना बड़ा है, चारों तरफ पूजा पाठ होता है, चारों तरफ पूजा होती है. एक छोटी सी मस्जिद है प्रीमाइसेस में, वो भी बर्दाश्त नहीं कर सकते, और आप हमसे उम्मीद कर रहे हैं कि आउट ऑफ द कोर्ट समझौता किया जाए.
Let's understand and decode this verdict, its ramifications, and does it really open Pandora's box? With three legals. Vikas Singh is former Additional Solicitor General of India. Arima Sundaram is senior advocate. We also have Faizan Mustafa, former Vice Chancellor of Nalsar University of Law. Thank you so much for your time. Vikas Singh, let me get straight into the verdict. And it is being seen as a victory for the Hindu side, for those 5 women petitioners, and a setback for the Muslim petitioners. What made the Muslim argument weak?
So, Marya, I don't know what has been argued, and to be frank, I have not seen the order also which has been passed today. I've only read it from the from the news feeds that have come so far. But there are apparently trying to make a distinction between turning a place into a changing the character of a place and vis-a-vis the right to worship in a particular place. Now, according to me, these are completely intertwined, and these can't be separated. Until the challenge to the Places of Worship Act, which is pending in Supreme Court, till some interim order is not passed in that matter, or till such time the act is not set aside, if you ask me, I don't see how this suit should be continuing and any adjudication being happening in this matter. So unless I see the actual judgment, I really can't comment. But that is my prima facie view, that this order has gone trying to make a distinction between conversion of a religious place to a right to. So it will be very just imagine somebody wanting to come and offer nawaz in a temple. It's something which is not done. So similarly, you can't say that I want to offer prayers in a mosque without it being converted into a temple. So really speaking, it is begging the real issue, and somebody will have to grapple with that issue at some stage. And according to me, it should have been now only.
Okay. Narima Sundaram, this exact point that is being made by Vikas Singh, petitioners have prayed for the right to worship, they got that. However, can this question really be sorted out or settled without determining the religious character of this place?
The point and issue is this. We are on the question of maintainability of a suit. That is, whether such a suit can be filed at all, assuming everything was right. There is certainly a bar to reopening questions of title, questions of when a place of worship has been in existence for a number of years, as the statute is. But this is not a suit for type. It's a suit for right to worship. And it appears to be a suit based on both custom and what I would call a civil right, not an ecclesiastical right necessarily, but definitely a civil right.
Okay.
So, as to whether this right is made out finally, as to whether all this can be proved in a court, is a matter to go for trial. The aim today was to see whether this suit should go for trial at all or is barred by some law. On the face of it, when the declaration is not with regard to either altering a place of worship and saying it can no longer be a place for the worship of a given community, given religion, denomination, but should be for somebody else. If that is not so, then it's not changing a place of worship. To ask for yourself having a right to worship there may not amount to a change of a place of worship. Equally, it is not a claim on a property right by which the right to the mosque is being claimed. Yes. And therefore, on the face of it, on the bare allegations in the plaint, it cannot be that the suit is barred by any law, which appears to be what the district court has said. Of course, this will be subject to various appeals which will be filed, I'm sure. But offhand, to comment on this judgment, would really say that the judgment has really only given these plaintiffs a right to proceed and say, all right, prove your case that your civil right or your right to worship has been in some manner been prevented. And we'll have to, in the trial, ensure that the trial does not get broadened into a question of seeing whether the place of the worship in the very mosque should be changed, or the religious denomination who can worship ought to be somebody else, or the mosque should be turned into a temple. Those are not the questions. And the court should also see that those issues don't go into it. But it's restricted to what the plaintiffs are claiming, which is they say we have a right to worship. Not that the mosque should not be there. But that seems to be the prayer, and that seems to be what has appealed to the district court, to say that it is maintainable and let it go ahead for trial. As to whether they would get the relief, whether they can establish this, as to whether they can show that what they are really asking for is not going to trammel on the religious rights of others will be a matter for trial and final decision.
Yes. So that is certainly the nature of petition, as you were pointing out rightly, Arima Sundaram, but you heard from Vishnu Jain. He seems to indicate that there are multiple petitions, and one petition is also about title of this entire site, which is Gyanvapi Mosque. Professor Faizan Mustafa, based on the evidence that is there already, can this place be converted into a temple until Places of Worship Act 1991 is there?
The whole question is, Marya, that the judge in Varanasi court today very clearly in his 26-page order says that these 5 women petitioners are not seeking conversion of place from from mosque to the temple. They are not making any ownership claim either. What he is saying that the petitioners merely want to worship. They have asserted that they were worshipping till 1993 and thereafter they have been stopped.
Yes.
And therefore the judge concludes that the 1991 Act prohibits conversion.
Yes.
But there is no relief of conversion sought in this petition. And that's why the 1991 Act does not apply. Similarly, he is saying that the 1991 Act would not apply in this case because there is a Kashi Vishwanath Temple Act of 1983.
It's very, very technical.
Passed by the UP Legislative Assembly, which defines a temple. And the argument of the petitioners is that this property within the meaning of Kashi Vishwanath Temple Act was declared as a property, as a temple. And if it was a temple in 1983, therefore the question of 1991 Act being applicable in this case simply does not arise. So I think the problem is far more complicated than it was commonly understood. As you go to the judgment, they say that even the property has not been registered properly as waqf. And of course, they say that Aurangzeb did not create a waqf. And the mere entry of a property as waqf in the revenue documents does not make it a waqf property. Now, these are all very, very important observations, highly technical and legal. I think it is a major setback to the Masjid Intizamiya, committee.
You know, Professor Mustafa, you have made an important point that there is a setback here, that there is a victor and a loser here. Do you think that this entire issue should have been settled out of court? Because I remember you speaking about it, and now the hearing will begin on 22nd. There is another petition before the Supreme Court. The issue will get even more vexed. It will divide the two communities even more.
Very good. Thank you, Marya. You recalled my earlier conversation with you. I am against litigation between the faith communities. These faith communities are not fighting for somebody's personal property. They are all fighting in the name of God.
Yes.
And ideally, in the name of God, there should be no fight.
Yes.
And that's why I had earlier on your show, when this whole Gyanvapi matter started, had said, and I reiterate, that it would be much better if the local Muslims of Varanasi and local Hindus of Varanasi sit together, have a dialogue, exclude all the politicians, exclude the clergy outside Varanasi, and think of a solution. If the problem can be solved by just permitting these 5 women to worship from some place, and prayers, Muslim prayers are also held and continued, that would be a win-win situation, because as you rightly recalled, in a litigation, only one party will win, the other party will lose. In mediation and in arbitration, in an out of settlement, both parties will win. It will be a win-win situation, both. Both will lose something, both will get something. And that's why I believe that between the religious communities, we should not think in terms of that it would amount to a surrender to majoritarianism. That should not be the spirit. We need to sit together and find a respectable, amicable, and a solution acceptable to the residents of both the communities.
Yes, and Vikas Singh, what does it really do to the 1991 Places of Worship Act? Is it increasingly becoming redundant because there are ways of subverting it?
So there is a challenge to that act which is pending in Supreme Court. But as I said earlier, that till the act remains or till the act is not, either withdrawn by the Parliament or repealed by the Parliament, or till the act is not set aside or quashed by the Supreme Court, because there is a very important legal issue involved in the act, in the challenge to the act, and that is that whether the centre has any right at all to bring this kind of a legislation, because it's definitely a matter covered by the state list, and the centre is denuded of its powers to legislate on this subject. But that's all to be argued in Supreme Court. So far, that argument is yet to happen. So I personally feel that till the act is there on the statute book, courts will have to respect that, and courts can't go ahead with a determination of such suits without the act being set aside or brought out of the way by a repeal.
Okay, Arima Sundaram, your take on what really happens to the petition that is there before the Supreme Court, because the Supreme Court judge, the bench that was headed by Justice Chandrachud Singh had clearly said that they would be taking the matter again up on 20th of October, and here the verdict has come and the hearing begins on 22nd of September.
No, the case before the Supreme Court will take into account. This case before the Supreme Court recognized that there was going to be a petition by which the maintainability was being questioned. The Supreme Court recognized that there would be an Order 711. The Supreme Court also recognized that that would be taken up first and said that there can be a status quo till that was decided. Now that has been decided, this will be brought to the notice of the Supreme Court. Will decide on it. But if they want to challenge the order which has been passed under 711, then that order has to be challenged in accordance with the civil procedure. As to whether they challenge it to the High Court, challenge it directly before the Supreme Court, it's a matter that they will decide. The party will decide. So that is a matter for each party to decide. Whether the parties who has today got the right to proceed with the trial is naturally very happy with that and wants to proceed with the trial. The party who wanted to stop the trial would be unhappy with it and would petition the court. But the earlier Supreme Court order very clearly recognized that there would be an application for the purpose of determining the maintainability of the case or whether it should be disposed of, dismissed under 711, and left it to the trial court to decide. And the trial court has now decided that. The correctness of it, of course, will be subject to appeals, will be subject to provisional jurisdiction, and that will be seen there. But you asked me a specific question as to whether I see some basis for the order of the district court. And I do find that basis in this, that it cannot be said that when what is being claimed is a right to worship alone and not to change the nature or character of the entire area, then it's a moot question and it's a matter which could go in for trial and cannot be dismissed outright on the ground of not being maintainable, being against law, or not disclosing a cause of action. Now, that is what the district court has seemed to say. And I cannot personally, at first blush, without reading the entire judgment, at first blush, I cannot say that that is erroneous. Why? Because it is not as though the defendants have been shut out. All that the plaintiffs have been allowed to do is to proceed. The refusal to dismiss on the ground of reject the plaintiff at this juncture, not a decision on the case itself. It's not a decision as to whether there is a right to worship. It's not a decision as to whether they will be allowed to worship. It's not a decision on any of those points. It's only a decision that they are given their day in court to try to prove their case. That is all the decision today is, and nothing more. If it's made out to be more, well, it's not so. And I do not see it as anything more than the court saying, look, you've made out some cause of action. You seem to distinguish the act and say the act does not apply. Well, these are matters for trial. Let the trial go on, and the trial will decide as to whether you're right or wrong.
Okay. Then in that case, Vikas Singh, are you of the opinion that the Places of Worship Act 1991 should be settled first before further judgment in this case, or the hearing should proceed in this case?
According to me, yes. And if you ask my very personal view, I feel that this act should not have been brought in place at all. And this act should not have, this act, Parliament would be well advised to repeal this act even today, because ultimately, why should a person be denied the right to agitate that this particular place was a temple and accordingly it should be restored to its original position like they did in the case of Babri Masjid? So why make an exception to Babri Masjid and say the others are to remain whatever they are in spite of whatever good case a petitioner may have? Because ultimately, Marya, you will recall that even in the Babri Masjid matter,
yes,
once the court decided, there was no unrest on that basis. So really speaking, the act should only limit itself to forcible conversion of a religious place from one religious community to the other. So that forcible conversion should not happen. But if a judicial interpretation is taking place or a judicial determination is taking place, and if on a proper legal judicial determination, if a competent court were to take a view, that per se will not be a matter which will create any unrest, like it did not happen in Babri Masjid. So Babri Masjid, the wrong was definitely for the demolition of the mosque, and which of course the Supreme Court has noticed also and tried to assuage the feelings of the Muslim community by giving them that alternative piece of land. But that was not correct. Nobody can justify that. So if you wanted to bring an act, you should have brought it limited only to forcible conversion and not to stay or to make redundant or to say that all these civil suits pending in any court in the country will abate after the coming in force of this act. So that, according to me, is a non-starter from the beginning. And Supreme Court will be well advised to either quash it, or the Parliament will be well advised to repeal this act.
Let me give the final words to you.
Limited to forcible conversions,
okay,
and not to legal conversions.
Okay, Professor Faizan Mustafa, you were talking about an amicable solution, a possible mediation at this stage. Don't you think that we have crossed that bridge already? And what really happens now to Jaunpur, Mathura and several such places where it is about Ganga Jamuni Tehzeeb, but it has become a point of division between the two communities? Will this verdict then, and the nature of what really happens, open Pandora's box, or you may call it floodgates?
It would, because the whole question is that what the judge is saying, that the 1991 Act prohibits conversion of a place of worship from one religion to another, but it does not bar the ascertainment of religious character of a place. I believe it is going to open a floodgate of litigation of this type, and that will not be good for the communal harmony of this country. So it's better that some give and take in the spirit of accommodation, in the spirit of mutual respect for each other is resolved. And that's why, there have been people who have been saying that these three places, Ayodhya, Kashi and Mathura, have special significance for the Hindus. And if some solution can be reached about these three places, then there would be, conducive environment to bring an end to, disputes about other places of worship. You see, some kind of out-of-box solution we had before that. What about the silent prayer? Yes. What about creating some space for multi-faith prayers in our places of worship. At the airports, we all go to multi-faith prayer rooms. So the country has evolved. Our constitutional democracy should evolve rather than having exclusivity. I understand that for a Muslim, it would be very difficult to pray at a place where you have idols. But after all, there is a historic evidence that this was a temple and a part of it was demolished.
Yes.
So maybe we can move forward. I think in constitutional law, there has been a conflict between directive principles and fundamental rights, and the courts evolved the concept of harmonious construction.
Yes.
Rather than saying that fundamental rights are superior to directive principles,
Yes.
they said find a way so that both can be given effect too. So my interest is, can we find a way in which both Hindu worshippers as well as Muslim worshippers, the management committees of both the places can reach some kind of a compromise and solution so that the politics in the name of religion can really be avoided.
We certainly hope it is avoided, but that's not happening, given how the entire issue is evolving itself. Thank you so much for your time, Professor Faizan Mustafa, Vikas Singh, and Senior Advocate Arima Sundaram. Shifting focus to the other story. A picture of khaki shots have erupted, has in fact led to war of words between the Congress and the BJP.
Those who are associated with a particular ideology, they should be killed, they should be eliminated, they have no place in the politics of Kerala. This is blatant instigation of violence, Mr. Rahul Gandhi.
हेट्रेड से आप जोड़ना चाहते हैं क्या? हेट्रेड वो पाल रखे हैं बहुत पहले से.
Those who stoke the fires of hatred, those who stoke the fire of bigotry and prejudice, must be prepared to take some things back.
A mega war of words has erupted between the Congress and the BJP after the official Twitter handle of the Congress party posted a picture of khaki shots of the RSS on fire with a caption, "Free the country from the shackles of hate and undo the damage done by the BJP RSS." Responding to the Congress party's tweet, the BJP said the picture is clearly a call for open violence and against people of a particular ideology. The Saffron Party demanded the Congress take down the picture immediately, and called the Bharat Jodo Yatra led by Rahul Gandhi the Bharat Todo and Aag Lagao Yatra. The Congress has stood by the tweet, saying it is a message against the divisive politics of the BJP. While the Congress has accused the BJP of playing diversionary politics, is the Congress losing control over the narrative surrounding its own political campaign by posting pictures of this nature? Charu Pragya, spokesperson of the BJP, is joining me. We also have Meeta Chakravarti, spokesperson of the Congress. Meeta Chakravarti, coming to you. Bharat Jodo was about uniting India. It was also about inflation and rising prices. But what does a picture of this nature really mean?
Okay, so in any democracy, there should be space for symbolic protest. The tweet clearly talks about to free the country from the shackles of hate and to undo some of the damage that the BJP and RSS's divisive politics has done to our great nation. So when we actually, in form of protest, when we actually go and burn an effigy, it's just symbolic protest. We do not mean to harm the person who we are protesting against.
Okay.
There has been a place for symbolic protest in democratic setup.
Okay. What is the symbolic protest with khaki shots? And if you remember, RSS has already opted for full pans. So what does these what do these shots really mean?
Even bigger reason. So when we are talking about a symbolic protest against RSS and BJP's politics of hatred and divisiveness, then it should be taken in that context.
Okay.
But it clearly shows how rattled the BJP is with the success and with the response we are getting.
For the longest time, the BJP has been saying Rahul Gandhi is inconsequential, he doesn't matter, that he's a failed leader. Then why is this Bharat Jodo Yatra and all the memes or whatever the Congress party is putting out rattling you?
Marya, first of all, if the Congress spokesperson has to explain why the tweet is symbolic and explain the meaning of a symbolic tweet, then obviously it was not as symbolic as that. I don't think anybody has to go around explaining burning the effigy and its meaning and how that is not equivalent to burning a real person. That just shows that the intention of Congress was not as innocent as they are suddenly pretending it is. That being said, it's not Rahul Gandhi who is relevant today. It is what Bharat Jodo Yatra is standing for. It is basically the people who are walking with Mr. Gandhi today in this yatra. It is the message which is being spread. It is the conversation which is being carried forward. And who does this conversation come forward from? It comes forward from a leader who talks about Jodoing Bharat, but at the same time, he has been one of the leading people who's talked about dividing India time and time again. So whether in the last Lok Sabha elections he tried to create a north-south divide, you have heard his statements. I don't know now whether it is because his political acumen is low, his communication skills are low, or he really means to tell the people of northern state of Uttar Pradesh that they are not as good as the people of Kerala. Eventually, he lost his election in Uttar Pradesh. He is a member of parliament from Kerala only.
Okay,
today.
Meeta Chakravarti wants to come in. Meeta.
The people who are walking with him are the same ones.
I would like to read out a few of the comments and quotes made by some tall BJP leaders. So when Anurag Thakur, a union minister of BJP, says "Gaddaro ko goli maro," is he not directly promoting violence? When Pragya Singh Thakur, a BJP MP, talks about Nathuram Godse Deshbhakt tha, Deshbhakt hai, is she not promoting terrorism? When Amit Shah calls Bangladeshi migrants termites, what kind of hate speech is that? Now, when we have exposed this divisive nature of politics and hate speech time and again, we have done that time and again. And
maybe
this is
like
what
Mr.
Bharat
Gandhi
Jodo
taking him along
Yatra
to Bharat
is
Jodo Yatra.
about.
That's what
Bharat
the India
Jodo Yatra is about economic inequality, it is about political equality, it is about social disharmony, the amount of hate politics that BJP and RSS is indulging in. So we have spelled out the objective of Bharat
No,
Jodo Yatra.
but I'm trying to understand from you. When you talk about this objective, why are these objectives not being communicated through your Twitter handle?
Exactly.
Why is this objective being talked about in the studios, but when it comes to the symbolic symbolism, because you yourself said no, right? Meeta, you just said that this is a symbolic protest. I'm trying to understand protest against what?
Protest against BJP and RSS divisive hate speech, divisive politics. I have just given you 3 quotations from Anurag Thakur to Amit Shah to Pragya Singh Thakur.
Okay, Charu Pragya, why are the BJP leaders openly propagating hate and violence?
Whether they want to live in Nathuram
So, you know, unfortunately, Marya, can the Congress spokesperson wait for her turn? Thank you.
Please.
So, unfortunately, the statement that Meeta is reading out today, she starts with the word traitor. What does she expect the India of today to do? Award a traitor? I am sorry, a traitor needs to be treated as a traitor. I am sorry, he doesn't agree. So, but why not? Don't we hang traitors? Don't we hang people who are rapists? So do not there. Why don't you discuss the kind of conversation Mr. Gandhi is indulging in this yatra? Why is he putting down Hindus and Hinduism? Why is he getting into a discussion which is on record, by the way? There is no way you can defend it. People walking with him are the same people who time and time again have professed hate, who have talked about dividing India, who have talked about appeasement politics, who have in fact said Bharat is to बैठे होंगे. These are the people who are working with Mr. Gandhi. I am sorry, from the ground there, I have not heard of those things that you are mentioning today. So
the whole motive of this yatra is to continue spreading hate and to continue spreading misinformation, as Congress has been doing for a very long time. We are not going to stand for it. Every single time an incident like this happens, it's our job to shine the light on it.
I need to come in there. So when we talk about very high rate of inflation, when we talk about very high rate of unemployment, 42% of India.
You are discussing how Shakti does not matter.
I did not interrupt.
No, but that's not the conversation. You are only saying Shakti is not important. There is one real God, and that is Jesus and His Father.
When you have a food inflation of 7.7%,
everything that she's saying right now, everything that she's saying right now is nothing has been discussed in this Bharat Jodo Yatra. What
you do not want to discuss people issues. You only want to take the discussion to Hindu-Muslim polarization. You only want to discuss communal topics, and hence you don't have any comeback. You're talking about a t-shirt. You are talking about a tweet.
You are the one
who
do not
want to talk about people issues, ma'am. BJP party is completely exposed because you do not want to talk about real issues that matter.
No, I'm
but
sorry.
you want to take the narrative back to communal polarization, ma'am. And
that
is the very, very unfortunate
you know what?
And that is what remains exposed. It's exposed
but
that how rattled you are with the success of this Bharat Jodo Yatra, because all you're doing is taking the narrative back to communal polarization. You're talking about the tweet, you're talking about the t-shirt.
But the question is, okay, so the numbers have come today, inflation figures have come today, the Congress party hasn't put out a single tweet, Rahul Gandhi hasn't said a single word. The only thing that is there on the Congress Twitter handle today is this khaki shorts which is on fire. So questions will be asked as to who's polarizing this entire discourse. Thank you so much for joining us, Meeta Chakravarti and Charu Pragya. We are slipping into a short break. Up next, Britain continues to mourn the passing of Queen Elizabeth II ahead of a funeral on September 19th. A special report after a quick break. Stay with us.